When the Kohberger prosecutors got all upset about potential tainting of the jury by a jury research poll, I don't know if they knew they had bigger fish to fry.
I think they forgot about Christ Church.
Hi, I'm attorney Andrew Myers here with a special edition of About the Law. I have a special guest today, Yolie Medina from Southern California. Yolie, thanks for joining us.
Thank you for having me.
Well, we're both attorneys. You're on the West Coast, I'm on the East Coast, so we'll try and have this conversation so that our viewers can follow us along. But I've followed you on other podcasts for a long time, and this is the first time we were able to get together.
Yeah.
So welcome. Welcome.
Thank you.
Why don't we just start out with a little bit of a background? The prosecution got all upset that there was a survey being done of potential jurors, and 400 of them were called. And then it turned out after 2 hearings and hours of, going back and forth, the survey's still going on. I thought that was kind of crazy.
Yeah, he let it go. And I figured the judge would have to allow it because the argument that the prosecution made was that the questions in the survey violated the gag order. But if that were the case, the prosecutor should have had a closed hearing rather than reading out the questions in open court. So
I agree 100%. I couldn't believe that was the objection, that these 400 potential jurors were contacted by this polling company, the survey company, I should say, 400 of them. And it was said by the prosecutor that those 400 were being tainted as potential jurors. And he got really upset about the whole thing. If you read the tone of the pleadings and then the tone of the whole thing in the actual hearing, I couldn't believe it when he actually, knowing that this was a public hearing that was being broadcast everywhere, and he started reading the questions. I'm saying to myself,
oh my goodness. Oh. And the other thing is, it's like he was trying to argue the defense, saying that those questions were prejudicial to the defendant. And in the judge's ruling, he said, well, I presume that the defense knows how to defend their client. So, it was a very strange argument that the prosecutor put forward. And it's all about his argument, the basis for what he's trying to accomplish. And the basis was just flawed from the beginning. I mean,
and the other thing that was really flawed about it, I think the judge soft pedaled it a little bit. When I actually read the final ruling that says that the study can keep going, the judge said nobody asked for this hearing to be closed, and he didn't come right out and say of all the hearings that should be closed, this was the one. But in any event, so
right. And then we have this discovery motion that they just had a hearing on the other day.
Yeah.
About closing the motion to compel discovery. So I think he's trying to be cautious now and trying to close the hearing. I have no idea what's going on, but it was a very strange court proceeding, that one.
It was a very strange court proceeding, and it seemed to me, and this is only me saying it, it seemed to me that the judge had already made up his mind in the very beginning, and it seemed to me that the whole thing was a waste of time. But the parties wanted a hearing, and Ann Taylor said, "What does the state have to hide? I mean, what am I missing here? You're an attorney, I'm an attorney. Let me ask you this: isn't there right to keep things quiet? Whether it's a non-dissemination order or sealing things or keeping things, isn't that the defendant's right to protect him against prejudice and tainting the jury pool and balancing against his right to a fair trial? Isn't that his right, not the prosecutor's right?"
As I understand it, it's his right.
Yeah.
The prosecution does not have a right to. They're not on trial. The prosecution isn't on trial. They don't have a right to a fair trial because they're not on trial. Now, if the state was a defendant, then they would have a right to a fair trial. But the state is not a defendant, so it's bizarre that the tone of these arguments, and it's just nonsensical to me. I have a hard time following. And I also think this judge may be overloaded, with other work. because
Yeah.
it seemed like it's a little too much that, I don't know. That's
Yeah, he
just what.
came right out and said when the party said, Ann Taylor said, well, I think we should have hearings every other week, twice a month. And the judge's first response was, I have a lot of work to do. I don't know if I can do that. So you're right. I mean, this is a district court. And I looked it up, and I mean, every state is different. I would never pretend to know how to do it in California. I don't even know how to do it in my two states, Massachusetts and New Hampshire. But I did look up the jurisdictional thing in Idaho, and the second judicial district court. They have jurisdiction over everything, drunk driving, misdemeanor,
Exactly.
you know,
Yeah, we have separate courts. Well, now the courts are kind of messed up because of the COVID lockdown. There's one county in Southern California, Riverside County, that is actually the civil trials are being delayed and delayed and delayed. And I have a civil trial there that is just, it's going on a year and a half now. It's keeps getting continued, not because we're not ready, but because there's no room in the
yeah,
courtroom. So the civil
yeah,
court cases are being heard. Well, criminal court cases are being heard in civil courtrooms, and they have a right to a speedy trial. So
right,
if they don't waive their right to a speedy trial and there's no courtroom available, charges get dismissed, and
really,
that's what's happening in Riverside.
yeah,
LA isn't so bad, but Riverside is bad. So I know that, yeah, in Idaho, that this judge hears everything. It's like
right,
there's no separation of civil courts, family courts.
right, exactly, right.
They might have separate family courts, but they have jurisdiction over everything. It's insane.
But yeah, you're right. He does. I was looking it up, and he does drunk driving and breaking and entering, and all of those criminal cases, but also contract disputes, personal injury stuff. I do personal injury stuff, and you do every now and then have to try a slip and fall or a car accident case when the insurance company doesn't want to give you a fair offer, and so he's trying all of those cases. And so I don't know anything about Moscow, Idaho. I really don't, but I know that the local courts that I'm involved in are very busy with all that stuff. And they generally try. One of the courthouses I go to, which is about 25 miles north of Boston, they have 6 courtrooms, and they're always going. So you go into session 1, they say you're going up to session 5 or session 4. So I get the impression that the city of Moscow has very limited judicial resources. So for him to take, hours and hours and hours on these issues and that was a non-issue really, as far as I'm concerned, the whole thing about the survey, because after 3 hours of hearings, okay, we're going to let the survey go.
And surveys are commonly done. I mean, I've had huge cases that it never got to that point, but it was considered, in terms of bias and the community and whatnot. But it just I never had to be involved in getting an expert to do a survey. But yeah, it's something that is done. And, for the person who became so alarmed because they were conducting a survey and reported it to the prosecution, that's kind of strange in and of itself.
Yeah, these things are done in the big cases. Mr. Edelman, the survey researcher, listed all the cases on which it's been done. A lot of big cases where it's been done. The George Floyd case, and one that's near and dear to me and close to home, the Boston bombing case. But yeah,
Right.
in the big cases, it has to be done because these are huge cases. I mean, who didn't hear about the Boston bombing, and who didn't hear about the George Floyd case? So it's important to do a study with someone that has the background and the brilliance that Mr. Edelman did to talk to people, not only what did they hear, but does that disqualify them from being a fair, impartial juror? So anyhow, the reason you and I got together today from the East Coast and the West Coast is because we were talking about how, all of this time and 4 hours of hearings on this survey, which only reached out to 400 potential jurors in Latah County, I should say. Well, we have a big issue where thousands of potential jurors in Latah County are prejudiced, right?
Right. And have a history. They have a history. Law enforcement and Christchurch have a history, and it's not a good history
No.
And also, religious students at the law school at University of Idaho have a history with the university and Scott Green, and it's not a good history either.
No.
So, in terms of what the prosecution should be looking at in terms of a bias, it seems they maybe are too focused on the survey questions and not focused on the bigger picture.
So to show people what we're talking about, here is an article that was done by Howard Blum. And I know a lot of people have issues with Howard Blum, but we have some other sources that we're going to look at also. And what we're looking at right now is, I'll go back to the beginning so I can show people what this is. This is The Eyes of a Killer, Part 7, which came out April 27th of 2024 by Howard Blum. I understand his book is going to be coming out soon. It began as a routine hearing, then came a pair of revelations that could upend the government's case against Brian Kohberger. So let me go back to the page I was on. On this page, Blum talks about how because something that Edelman, who we just talked about, the surveyor, the learned statistician and social psychologist, is not measuring, that's the allegiance of many people in Moscow to Pastor Doug Wilson's Christ Church. The Kirkers, as the Christ Church parishioners proudly call themselves, number about 2,000. And that's a significant percentage of the Moscow jury pool, especially when it is very likely that anyone associated with the university will be peremptorily struck as potential jurors. That's a lot.
It is a lot for
How
that.
How can they do peremptory strikes for 2,000 people?
I just, I mean, I have no idea. I have no idea how they would do that. You only get a certain amount.
Right. So this goes on to say, and the church, as personified by Pastor Wilson, is in a state of war with local officials. Arrests and court cases against church members, including Pastor Wilson's son and grandson, for their activities in protest of pandemic restrictions, have deeply frayed relations with Moscow authorities. You'd think we'd be a natural constituency for Back the Blue, he told me during a conversation in his book-filled office in downtown Moscow. But after what we have experienced, I think that if any of my parishioners are on the jury, I'd tell them to go in with an open mind.
Yeah. So contrary to what people think that, the city of Moscow or the Latah County is already biased and has made up their mind about Brian Kohberger, that may not be the case.
No. Let's see. Mr. Blum goes on to say, for the pastor, his tone, steady, redolent of a clear-headed reason, went on to explain that if a Moscow cop were to testify against Kohberger, his parishioners would have good cause to be skeptical. After all, he said, still bristling over the court cases involving church members, we know their officers have lied on the stand before. That's a big statement.
A huge statement. Very interesting.
But for now, there's only delay when the judge talks about the scheduling, the trial, all the potential dates are a year in the future, and none have been offered with any genuine conviction. There's no telling when Brian Kohberger will have to face the judgment of a jury of his peers. Okay, so that's the article that just came out. So when I saw this, as you know, I said, wait a minute, I'm scratching my head. There was more. Blum talked about this before. So here's his previous article that came out July 2023, The Eyes of a Killer, Part 5. And here again, he buried it down on the bottom. So we're going to go way down to the bottom of this article. In a heartland community such as Moscow, I had expected that a predilection for Old Testament eye for an eye justice. That's writing. Some people like this kind of writing and some don't.
Yes, these big words.
Yeah, the prosecution. I worked in TV. I worked as a TV reporter, and we were told. Okay, I'll just say it. We were told to write for a 5th grade education.
Well,
the big words, no, get rid of them all.
Yeah. Yep.
Multi-syllabic words were out. No more than 2, even 3-syllable words. Okay. So anyhow, all right, let's get into this. So we go on with the Blum article, but it takes just a conversation with Pastor Doug Wilson, the head of the town's ultra-conservative Christ Church, to convince me that I am wrong. The Kirkers, as the parishioners are commonly known, are increasingly a dominating presence in Moscow, already 2,000 or so strong, perhaps nearly a half of the town's non-university affiliated jury pool, perhaps nearly half of the
Yeah.
town's non-university affiliated jury pool. They control a bookstore and a coffee shop on Main Street, as well as 2 separate real estate offices and their own college. Only here's the thing: the church, as personified by Wilson, is in a state of war with town authorities, including the police department, whose investigation had built the case against Kohberger. So that's big. I
It
mean,
is. It's huge. And to think that they wasted all this time on these questions that were out in the media and waste hours of the court's time and, on something that eventually was a non-issue, is ridiculous.
last Christmas, just before Kohberger's arrest, so we're talking, remember, this article came out in the summer of 2023. So they're talking about the Christmas of 2022, just before Kohberger's arrest. Wilson shared his raw feelings about the town fathers in one of the weekly encyclicals that he sent to his flock. Our local city government, law enforcement included, is a nest of incompetence and corruption, he told the church members. And rather than turning the other cheek, he went on with measured force. If the additional scrutiny over the murder cases is part of what brings about a much needed house cleaning, then we should be grateful for that, but without any unlawful gloating. So he's actually attacking the police. He's not only telling people to question the police, he's attacking them.
Yeah. And, with all the craziness surrounding the PCA, just various things that in the investigation, how it involved the FBI and Idaho State and everything else, I see that any potential juror who's affiliated to Christ Church just might have some underlying bias. And if it's half of the non-university population, that's a large population.
Oh, that's huge. And that's huge. You're right. And so the 400 in Ladakh County that were approached by the pollster just pale in comparison to this.
Right.
Okay, so we're almost done with this article. The roots of this church state animosity stem from several police arrests and subsequent lawsuits local officials filed against Christ Church parishioners, including Wilson's son and his grandson. Boy, there's no way to anger a minister than to sue his son and grandson.
Right.
The latter now a student at New York's Columbia University for a maskless public pray-in during the pandemic and a few stickers protesting coronavirus restrictions affixed to a town lamppost. And when I recently spoke with Wilson in his book-lined windowless office just off Main Street, he was still unforgiving. So I think some of this in the other article was a rehash of this.
Yeah.
But nonetheless, this guy is preaching to an audience of 2,000 people, and he's saying in this last paragraph, as if all of this were not enough to keep the prosecution up at night, Wilson did not flinch from making his way to what is now the bottom legal line of the Moscow murders. From what I've read, there are a lot of problems with the case, he said. There are a lot of questions that still need to be answered. He concluded with a firm and indignant blast. I think it's very possible the prosecution has the wrong man.
Yeah.
So
interesting.
So this is a guy that preaches to 2,000 people, and we have to remember that people aren't forced to go to church; they go to church because they want to, and so this is an audience that is listening to it of their own volition. And
the stories that go around, I mean, it's not only the parishioners, but parishioners know other people who aren't necessarily parishioners, and they talk amongst themselves, and even people who are not parishioners might have seen what went on and might have an opinion about the police.
That's a good point because, it said in the article that the church has a bookstore and a coffee shop.
Yes.
Now, in this day and age, a bookstore, last time I went into my favorite bookstore, there's fewer and fewer books and fewer people. But a coffee shop, that's a gathering place.
Yep.
So not
People
necessarily.
talk
Yeah.
and,
Yeah. So now the next thing I want to do is go to what we just read talked about lawsuits that went back and forth. So we were talking about lawsuits between the city of Moscow and the church. Here's an article about the city of Moscow reaching a settlement with members of Christ Church following arrests at a mass protest. Moscow, Idaho, a settlement has finally been reached today in the civil suit between the city of Moscow and Christ Church. Gabriel Wrench and Sean and Rachel Bonnet filed a civil lawsuit against the city of Moscow and several city employees after a gathering that occurred at City Hall in September of 2020. Boy, that was right in the middle of the pandemic.
right.
Wrench and Bonnets, all members of Christ Church, participated in a protest alongside other congregants without masks outside of City Hall. And they were protesting the crackdown on masking at their services. So the protest, how ironic, they're protesting the real crackdown on masks and church services. And they didn't wear masks and they were arrested.
Wow.
The protest consisted of singing psalms and standing close together, violating social distancing regulations in place at the time. Court documents say that Wrench and Bonnets declined to physically distance and provide information to officers. Wrench was arrested and booked into the Latah County Jail, but soon was released by Sheriff Richie Skiles. Shortly later, Wrench and Bonnets filed a civil lawsuit against the city for wrongful arrest. Now, 2 years later, Wrench, alongside the Bonnets, have reached a settlement with the city of Moscow in which Idaho County's risk management program will pay $300,000.
That's a lot.
That's a lot of money.
Yeah, and considering that, it's a wrongful arrest or violation of their civil rights, and there's no injury, there's no physical injury to it, and it's $300,000. That's a lot for not having any type of, physical injury.
That's your area of the law. That's your area of the law, so you would know.
Yeah.
So in addition to that, though, $300,000 is a lot of money for a smallish town. The city of Moscow is not that big. And, the taxpayers can't be very happy about that. I guess the underlying claim was that these people held a demonstration. Hopefully they had a permit. I don't know anything about Idaho, but where I live, you got to have a permit to do these things. But they're having a demonstration, and if they're standing too close. All right, you and I might differ on this, but I think there was, in my personal opinion, and I know people will disagree with me, I think there was an overreach about all of that during the pandemic. I really do.
Well, in retrospect, I do. In retrospect, I didn't know. They talked about this virus, and I'm like, oh my God.
Yeah.
But in retrospect, I don't know. I certainly don't want to get in trouble, but I also don't want to be restricted like that, because it really affected my work with courts and things like that. And
yeah, it affected all of us. I don't know about where you are, but there's a little bit of a sidetrack. But where I am, court continued pretty much with court call, Zoom, and other things like that. They didn't do that where you are.
They locked down for approximately 2 months where nothing was going on.
Okay.
And then they started with the Zoom or whatever, but the technology was so bad on some of these hearings. It sounded like the Charlie Brown teachers talking. Yeah, it sounded like, and the judge would be wearing a mask in a courtroom with nobody there, and we couldn't hear, and the technology was kind of staticky, and so it took a while.
I was involved in one crazy regulatory dispute over utility rates, and there were not only about half a dozen attorneys for the utility, and at least 3 or 4 people for the Utilities Commission, but then there are about 6 or 8 of us interveners, and we all had to get together on Zoom. It took them an hour.
That's exactly how it was. And then I would peer and I'd have this echo and I couldn't figure out how to, and people were having so many problems and but now everything is through Zoom.
Yeah. Now.
And actually I haven't had to in January, I went to a mandatory settlement conference that was in person at the court, but since it's been it's been a long time since I've had to step foot in a court for a hearing.
Yeah, same here. I just mediated a case last week with a recalcitrant insurance company. Of course, to me, they're all recalcitrant. And I'm way north of Boston. I'm, 30, 35 miles north of Boston. And the mediator, who is very good, is that amount of distance south of Boston. And the other attorney is west of Boston. So, I mean, Zoom is the best invention since sliced bread, as far as I'm concerned, because in the old days, I had to drive through the city. And all right, so we're sidetracking.
Driving to LA to get to a case management conference at 8 to be there at 8:30, driving from my area to there in the morning. It's a waste of time. But now we have Zoom.
Well, same with Boston. Say they spent I think $25 billion with a B to take the expressway through town and bury it in a tunnel back in the 1990s. It didn't improve things one bit. It's just the traffic is still awful. So anyhow, all right. So you have a couple of TV reports you want me to share here. So while I find them, do you want to tell us what we're going to be looking at in a minute?
Sure. There are reports by students, law students. One of the videos is a report regarding law students at the University of Idaho who had religious beliefs and expressed those religious beliefs. And they were met with some interference, and they were actually, I believe, they were banned from something.
Universities are supposed to be the marketplace of ideas where students can engage in debates and exchange ideas, whether they agree or disagree, but that's not happening freely at the University of Idaho. Our clients, Peter, Mark, and Ryan, are members of the Christian Legal Society. And as part of that, they were engaged in a prayer meeting near an event called the Moment of Community, about coming together. And so they were holding a prayer meeting. A student came over and asked them about their beliefs. The student ended up complaining, denouncing the Christian Legal Society at an American Bar Association meeting. And that's fine. You can have freedom of speech right to denounce others, but not to do what the University of Idaho did, which is to go after these Christian students and to issue no contact orders against them, telling them they can't access certain areas of campus or even have contact with students just because a student may disagree with their views.
Yolie, I'm going to stop it right there just for a second and ask you, is this as crazy as I think it is? Is this the University of Idaho actually went to court and got some kind of and enjoined these students from having contact with the university for their beliefs?
That's they stopped them from being able to access a certain part of the university. That's how I understand it. But they did go to court and get a no contact order.
What kind of a court? Well, I don't know all the facts. And so, as attorneys, we, really need to know all the facts before we can really, shade it our way. But I mean, what kind of a court would issue injunction against Christian kids wanting to express their, I don't get it.
Well, it would depend on what the paperwork was in, what it said in the paperwork and declarations or whatever. But what kind of a court would do that is a good question, because this attorney makes a lot of sense. I'm not a very religious person, not in terms of going to church but still, people have religious beliefs just like they have any other belief, and for court to issue a no contact order, and I'm not sure if that's the same as a restraining order, what we have in California, but in any event, they were banned from the university, and I believe they were banned, and it's not really clear, they were banned from being able to access a certain part of the university or engage in certain activities in the university. So they were being somewhat punished according to this attorney. and the, I guess it was a no contact order is what they call it. But yeah, that's crazy.
I don't understand. I don't understand why a university would do something. Let's finish this up, and then we'll get into the other one. But I don't understand why a university would do this. I mean, like the attorney that's on the right-hand side of our screen is saying, I guess, universities are supposed to be open. Maybe I'm old and showing my age, but universities are supposed to be open and be for the exchange of ideas. Is that no longer the case, at least at the University of Idaho?
Well, it all resulted by a student complaining about these law students voicing their opinion. So one complaint from one student ended up restricting them from doing what they would normally do, and it's kind of scary. So when you think about it, religious people in Moscow might have a jaded view of the university in light of this issue that occurred. And I believe that the students filed the lawsuit and they were able to reach a settlement with the university and Scott Green. They filed the lawsuit against University of Idaho and Scott Green.
And the university and Scott Green have certainly put their tentacles way deep into the Kohberger case.
Right. And so that's another issue that could affect, jury pools and how the jury might view the University of Idaho, even though they're not a defendant. But, Scott Green wrote a book, and I mean, it's crazy.
Oh, good grief. Okay, we'll put a pin on that. We're going to come back to that, and we're going to come back to getting a fair jury in Moscow. Which let's just finish this up briefly.
We do intend to file what's called a motion for preliminary injunction with the court. That is to ask the court to remove these no contact orders, to restore our clients' First Amendment rights and their ability to access campus and speak freely on campus, just like every other student. And that's what universities should be about. There shouldn't be any need for an injunction in this case, but we will plan to file one if the university doesn't immediately revoke these no contact orders.
Yeah, I just don't understand that. I guess you have to read the pleadings to figure it out, but that a university would actually file something against students for any religious beliefs, especially in light of some of the things that are going on now. Now, what's this other video that you want me to show here?
This is a news report regarding the church singing event, and Idaho was sued over it. That resulted in the $300,000 settlement. So this is just the news report about it.
Oh, about the settlement that we talked about earlier?
Yes.
Gabe Wrench was arrested along with a couple others for reportedly not following coronavirus safety measures during a church singing event last fall in Moscow. The group filed a federal lawsuit yesterday claiming Moscow police officers had, quote, reckless indifference to their rights. Wrench goes on to say that they were prosecuted for criminal activity when there was no violation of the law.
So what is going on out there in Moscow? It's a small town. Nobody ever heard of it. I'll admit I never heard of it before these horrible crimes. Are they even going to be able to get a impartial jury out in Latah County?
I don't know. I kind of highly doubt it. One way or another, there's probably going to be some bias, and the question is going to be, even though these jurors have a bias, if they do have a bias, can they set that bias aside and look at it objectively? And that's a hard thing to do.
It is a hard thing to do. I mean, I don't know, maybe I was thinking about this before we went on. Those of us that are in the true crime YouTube community, I hate that characterization, but it's there. I mean, you pay close attention to these cases. I pay close attention to these cases, and I have long before there was even such a thing as YouTube. I'm a big true crime reader. I read a lot of Ann Rule's books. I hope to before I pass, which hopefully is a million years from now. But so people like you and I, are on top of the Idaho 4 case. But as alarming as it may sound, I think there are people that don't know anything about it. I just assumed that everybody knew about the case. I was in the gym a few weeks ago, and someone was asking me about my YouTube channel. And they had never heard of the Idaho 4 case, and they hadn't heard of Kohberger. And the more I talked to them, they went, oh, yeah, oh, yeah, oh, yeah. And then the light came on. But there's not going to be very many people like that out in Latah County.
No.
Are there?
No.
I mean, I don't know.
No, it's affected their whole town. I mean, you know, they had YouTubers going over there looking around, looky-loos. They tore down the house. It was a big deal. I mean, you know, I'm sure that the county knows about the case.
Of course they do. Of course
they have to know.
Plus,
And
if you run into somebody that doesn't read a newspaper or watch TV or watch YouTube and knows nothing about this case, do you want that person on your jury?
I don't know.
I mean, that they don't care at all to keep current with current events. That kind of tells me about the person that, you know, I don't, but I don't know. I just don't see how they can do a fair and impartial jury on this case in that county. But the prosecutor, William Thompson, is really, he wants to hang on to this case. He just wants to keep it there. I don't see how he's going to do it.
Yeah, I don't either. And I don't know, you know, the way that judge rules, you know, his rulings. I'm trying to follow his logic in certain things, and sometimes I can't. I don't understand. And maybe it's because some of the evidence is sealed. But, you know, in other words, when they talked about providing expert reports, like, how is Ann Taylor supposed to provide an expert report when she doesn't have all the discovery for the expert to review, like the CASP report and all that? You know?
Right. They only have the draft. I hate to say this, and I've said it before, so I'll say it again. When I go to court, generally speaking, I find that the judges are very well prepared. Either they or their clerks have read my pleadings, and they ask me very sharp, focused questions. They'll give us time to argue. They'll give us time to make our point. But at the same time, they are very conscious of how busy the court's out. Now, maybe that's because the courts in the area where I am are extremely busy, and they don't have time for all this fall-de-roll. But my observation is that this court really isn't up to this case. This is a very complicated case. There's a lot of background, a lot of pleadings, a lot of litigation. You know the I-Corps website as well as I do. It's not measured by pages, but it goes on forever from the original probable cause affidavit back in December of 2022 to now. And it seems like every time we did a podcast, I don't know, maybe 10 days ago, where we actually went through the I-Corps and showed people, you know, what's in there and how much of it's been sealed. And in the time it took me to come home, have dinner, walk the dog, there were 3 new documents.
Yeah, it is document intensive, and I don't understand. They're very short. I mean, well, you know, in California, we have statutes that talk about hearings. You know, whenever you file a motion, you get a hearing, you have to file it a certain day. In this type of setting, it seems like just like it's not clear to me when you're getting a hearing, when you're not, or what you're, you know what I mean? Like, it's just kind of like the statutes. I mean, I don't have time to read all the Idaho statutes, but
no,
the you know, the statutes in California are very specific. Like, if you want to file a motion, a demurrer, which is like a motion to dismiss, you have to serve it and reserve a hearing date. And it's up to the plaintiff or the person filing the motion to reserve the date with the court per the code. Like, this isn't something that the judge nilly-willy says, okay, well, I guess I better have a hearing on this.
Well, even when there is a hearing, here's my perception. Let's go back to the issue of the survey that was done of 400 residents of Latah County. The prosecutor was up in arms. He was furious, really, about the whole thing, and he started filing motions, and he got 2 hearings, not 1, but 2. The first hearing went on for about an hour, and the second hearing went on for 2.5 hours. It just kept going and going and going, and Ann Taylor played the PowerPoint, but not until after they had argued for 25 minutes as to whether they were going to watch the PowerPoint. And it went on. And so there's, I said this in one of my other episodes, but there's, 3 hours of time that the court could have been doing other things, like doing a status conference on what's going on to get to the bottom of the 51 terabytes. Give us a status conference on whether you guys are conferencing the discovery. Give us a status report on the video. Give us a status. There's just so many issues, as you pointed out before, in this case. In my view, the whole thing was a waste of time. They just wasted hours of court time at a time when court resources are precious. The courts only have so much time. And as we pointed out before, this particular court is busy with drunk driving cases, contract disputes, you name it. And they spend this amount of time. In my experience, the judges that I go before are very well prepared. They've read the paperwork. They ask you pointed questions. They make a ruling and they move on.
Right. Sometimes they take matters under submission, but in our court system here in California, usually they provide a tentative ruling, a ruling as to how they're going to rule. And you get a chance to argue, and then the court will either say, I adopt my tentative ruling with these additions, or they say they take it under submission, and then they send out a ruling shortly thereafter. But this judge takes a long time to get his rulings out, and I guess it's the workload. I mean, I don't know, but it's certainly very disorganized for me to listen to these court hearings. It drives me crazy. It seems like they just deteriorate after so long. It's kind of like at the end of the hearing, it's like, okay, so what are we doing? What's happening?
Yeah, and then he has to check his book and decide when the next hearing is going to be, and it goes on and on and on and on and on. And yes, I know that as awful as these murders were, and the four families, and I've talked to some of them, they're berserk that this is taking so long. I do understand that the present defendant, Mr. Kohberger, has an absolute right to a fair trial, and he has an absolute right to have all these issues flushed out. But I don't think that the administration of justice is really up to it in this case. And I said this. Let me ask you a question as an attorney that does a lot of discovery, right? I had said in a previous episode, this discovery has gotten out of control. There are now 15 requests by Ann Taylor for supplemental requests for discovery, and there are now 5 motions to compel. I said, bring in a discovery master.
A referee. Yeah, discovery referee. Yes, and I was actually involved in a case long ago, but involving a university where there was a discovery referee, and there was one court reporting office that was responsible for receiving all the discovery where it was deposited. And this was back in the day, the early 2000s. So, the capability of having that back then was available. So nowadays, it's certainly available where they can have a court reporter's office as a deposit and have a discovery referee. And the discovery referee makes recommendations and issues orders, and then the court can adopt them or not. But it saves a lot of time.
Exactly. You call it a referee, that's fine.
Magistrate. Yeah,
no, that's fine. Here we would call it a master. And I had actually done some research and gone into a journal, and actually an organization, an entity that does this. They do discovery masters and it's the same thing that you're using the term referee for. And they, first of all, the two parties have to agree, and we're mature professionals. We can find somebody that they agree and I agree, then bring the person in. It's exactly the same process you just mentioned, but this would take a lot of the burden off of this judge who has to try drunk driving and contract disputes and everything else. Let the discovery be taken off, because now they've had a 1-hour hearing on whether or not to make the hearing open. And my perception,
not a hearing.
Yeah, a hearing about a hearing. My perception was the judge had already made up his mind before that hearing started. So now on the 14th, there's going to be another hearing on the discovery, the 2 motions to compel. Then the next date, I believe, is the 16th. They're going to do the IgG DNA show again. So it's just.
And the question is, there's going to be, I thought they said they were going to have a hearing on his alibi at some point. But that hasn't been set. I thought I heard that. I don't know.
Yeah, you're right. I'm not as up to date on the pleadings. I think this was the day that I looked at the at the ICOR website, and then I went home and walked the dog and had dinner, and there were 3 more things. And at that point, my mind was just overloaded for that day. I
Yeah.
tend to get overloaded. I think you're right. I think the alibi, they want to kick out the alibi.
Yeah, they basically said, the prosecution basically said that this isn't an alibi and we're not going to respond to it because it's not an alibi. We're objecting to it. But if the court does find that it is an alibi, then we'll respond to it. It's just, but let me ask you a question.
Sure.
If somebody is facing the death penalty, I would imagine that they could get an alibi, like a last minute witness, that comes and says, I saw
Absolutely.
him. And there's a statute that says that you have to get your alibi in by a certain date in Idaho, which to me, I find that strange.
No, I agree with the premise behind your question. I mean, they're putting him before a firing squad if he's found guilty, or that's potentially what could happen to him. So if I'm in Ann Taylor's shoes, which I'm not certified to do a death penalty case, but if I'm in her shoes, yes, absolutely. I'm doing everything I could possibly doing. I'm bringing 5, 6, 7, 8 motions to compel. But yes, I think actually if somebody comes forward, because there's reasons people don't want to come forward in a case like this. I mean, just the harassment. I mean, I don't want to talk about Bethany Funk, but I will, because she has felt just overwhelmed by the number of people that want to get to her and find out what that exculpatory evidence was. So to get to your question directly, if somebody comes up the day before the trial and says, yeah, I saw Brian Kohberger, I'm a clerk at the 7-Eleven, and I remember him coming in and buying a Slurpee, and here's the receipt. I think a court would be loath to not allow that witness on the stand. The question is credibility. Who is this witness?
Yeah.
Are they credible? Were they drunk? Do they have so I think the answer to your question is, the state of Idaho or the other 49 states can pass whatever statutes that they want. But as you and I both know, it's the Constitution that has to determine whether that statute is valid. So I think if this is a hypothetical, but if Mr. Kohberger did come up with an alibi witness like that at the 11th hour, and the court did not allow him on the stand, I don't care about their statute. They can stuff that in the shredder. That's going to be overturned on appeal.
Yeah, that's how I felt. That's how I feel about it. And
that's only my opinion, but I mean, the rights of the defendant to a fair trial are pretty much paramount to these statutes.
Yeah, and so a big to do about getting in his alibi. Okay, so she doesn't even have all the discovery yet, and it's if it's the truth that he was out driving around, if that's the truth that he went to this park or what he was driving around or whatever. I mean, if that's the truth, then that's the truth. People who live alone don't always have alibis because they could be asleep and there's nobody there to verify that they're asleep.
Yeah, my first impression when I first read the alibi, what the hell is this?
Yeah.
But then I'm thinking to myself, I mean, either that information is in his phone or not. These things track us in a bunch of different ways. There is not only the cell towers that ping, but there's also geolocation. And my limited understanding is that even if it's off, or even if it's out of range temporarily, the geolocation stuff is still in there because it comes down from the satellites, not the local pinging. And so there's a certain amount of geolocation stuff that's in there anyhow. And my understanding of the technology is that they can dig it out. So she's correct to be asking for it. Even if my initial impression was correct, and I don't think it was, but my initial impression was like everybody else, he was out driving around. What a bunch of BS that is. Doesn't he have a right to bring his alibi? And then it's up to the jury to determine whether it's right or not.
Yeah, whether they believe it or not.
Right, exactly. So
given his history, because there's going to be mitigating factors that a mitigating expert witness is going to talk about if he is convicted. Okay.
Right.
But that's after if he gets convicted. But given his background, I would think, what we know, we don't know much, and he's never said a word about
right.
this crime, so we don't really know much to gauge what he's like. But, some people do. I mean, that's why you take babies when they're crying. You drive them around so they can fall asleep, so they can calm down,
One of my regrets in covering this whole thing is I actually had a conversation with when the alibi initially was filed in the first pleading last August of 2023. I was expressing my initial reaction that I told you about, and a woman actually called me from Idaho, and she said, I went to school at University of Idaho, and she went to school at University of Washington in Pullman. And she said, we went over, not only did we go over to Moscow all the time because it's cooler. The Walmart is open longer hours. There's more stores. There's the vegan place. There's more bookstores, coffee shops, things like that. But she also said, yeah, it's a thing. People just drive around. And I didn't record this. I was just on the Zoom, and I wish I had. At first, when I had this conversation with her, I thought, I don't know. But I wish I could get her to call me back, because she said, yeah, it's a thing. If you're in a dorm or an apartment building and it's noisy or whatever, if you got a nice car with a nice sound system, it's a thing. People actually drive around.
Yeah. Well, and people who have anxiety do that too. If they can't sleep, it kind of calms down. They roll down the windows, and so I mean, who knows? I just hope that a fair trial can be had, whether it's in Moscow, Idaho, or somewhere else.
Idaho. I was speaking to an attorney in Idaho a couple of weeks ago, and he said, Andy, you don't understand. Idaho is a huge state. It starts up at the Canadian border and it goes all the way down to Nevada. It's a huge state. It takes hours and hours and hours to drive from the northernmost point of it to the southernmost point. So maybe it's possible that they could move it. I personally don't see how they can get a fair trial in Moscow, Idaho. I just don't see it happening.
I kind of don't.
All right.
Yeah, I don't see that, but you never know. I mean,
no, you never know. You never know. All right, Yolie, it's great to get together with you.
Yeah.
I've seen you on other creators' podcasts, and it's interesting to hear your input. And so I'm glad we did this. We'll have to do it again.
Yeah, we'll have to do it again on a different subject. One of these side subjects, maybe go into more depth.
Yolie, thank you very much. Thank you very much for being with us. If you're still with us, viewers, remember always to be kind and pleasant, whether you're in the supermarket or the gas station, and also in our comments down below. Please remember to subscribe and to share this with your friends, and we hope that you have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts, and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. After that final gavel, Lainey and I always say, and that's that.
And that's that.
Okay, I forgot. I feel terrible. I didn't mention Lainey. And people are going to think something nefarious is up. No, I asked her if she wanted to come on to record this session. No, she's got stuff to do. She's
yeah, it happens. I don't think people will think it's anything nefarious.
she's got all kinds. She's a busy person. She's got all kinds of stuff going on in her life, and she said, "No, have fun. I want to meet Yolie some other time." But all right. So
yeah, but you never know what people think. Sometimes people think, "Oh my God, where's Lainey? What happened to Lainey?"
People make the craziest comments. People. I don't know if you read CJ's comments, and I don't know if he gets the same type of comments, but I got comments like, "You're an attorney. How can you be an attorney and think?" And then just fill in the blank. They're just really.
I tend not to read the comments, unfortunately, but I do see when you guys address the comments. I like that. I like that you guys address the comments because it's a interaction. See, with CJ, he does lives, so there's chat. And, it's like a community. And what I like about that is it kind of reminds me of a jury. Like, you want the jury to get along, and chat like amongst themselves about the case when they're deliberating.
Yeah.
And so, it's interesting. It's interesting. But yeah, the comments after the show, I rarely read those because sometimes I leave a comment, but I'm not going to get all stressed out because somebody says that I'm stupid or boring or.
Oh, I don't get stressed out because, like I said before, I was a TV reporter before, and we would drive down the street with with the logo of the local TV station, and people would, at a red light, people would roll down their windows and say, "Yeah, holes."
Yeah, I mean, it's crazy.
We called the cars hole magnets. So people would give us a hard time all the time. You'd be trying to do a story after a fire or something like that, and your job was to go ask people how they feel, which is stupid. But the assignment desk is yelling in my ear, "Go ask people how they feel." So you're knocking on doors, and people are telling you, "Go yourself."
Yeah, that's like total rejection, right? And that's that. Okay, bye-bye.
Bye.